Hello everyone, today's commentary concerns the close connection between property rights and maintenance of a free and democratic society. It's called Law Becomes Plunder, a Destruction of Property Rights in Canada. We'll begin with a quotation from Frederic Bastiat, who wrote, "Property, the right to enjoy the fruits of one's labor, the right to work, to develop, to exercise one's faculties according to one's own understanding, without the state intervening otherwise than by its protective action. This is what is meant by liberty." There once was a time when justice meant something simple in this country: impartiality, fairness, and equal application of law. But in Canada today, that notion is collapsing in real time. A nonviolent protester like Tamara Lich can face 7 years in prison for mischief, while men convicted of raping children, shooting at police, or killing entire families in drunk driving incidents often receive shockingly lenient sentences. Frederic Bastiat saw this coming nearly 2 centuries ago. In his 1850 treatise entitled The Law, he warned that once the state starts to use law not to protect life, liberty, and property, but to redistribute, punish, and re-engineer society, then the law itself becomes criminal. Quote, "When plunder is organized by the law for the profit of those who make the law, all plundered classes try somehow to enter into the making of laws." End quote. Canada today is now firmly within this phase. What we call law is often nothing more than legally sanctioned theft, favoritism, and political persecution. Bastiat's central thesis is disarmingly simple. Law is the collective use of force to prevent injustice. It is not the creation of morality, wealth, virtue, or equality. It is a negative force, a shield against coercion, not a tool to impose dreams. So what happens when such force is no longer used to defend, but to redistribute? What happens when the law no longer protects property, but becomes a method for violating it? Bastiat called this legal plunder. And he warned that when this happens, society becomes divided into 2 classes: those who exploit the work of others and those whose work is exploited. Nowhere is this legal plunder more visible than in Canada's tax and transfer regime. According to the federal government's own 2025 report on federal tax expenditures, recent immigrants received 205% more in child benefits than native-born Canadians. Transgender and non-binary recipients received 1,343% more than men. Women received 3,157% more. These are not distributions based upon need. They are formulas based solely upon identity politics. The law in Canada now functions as a tool of engineered outcomes, not of justice. Bastiat described this as socialism masquerading as virtue. Quote, "As the result of systems and of its efforts, it would seem that socialism can scarcely help perceiving the monster of legal plunder. But what does it do? It disguises it cleverly from others and even from itself, under the seductive names of fraternity, solidarity, organization, association. It is not free association, but the forms of association that they would impose upon us. It is not spontaneous fraternity, but legal fraternity. It is not providential solidarity, but artificial solidarity, which is only an unjust displacement of responsibility." End quote. Bastiat thus saw right through transparent leftist language games. Take, for example, the case in a Quebec court which reduced a drug trafficker's sentence based solely upon his race. The judge cited systemic oppression and cultural context as mitigating factors. This is the death knell for the rule of law. If one person's punishment is reduced based upon his identity, then another's may be increased for the same rationale. Suddenly, we have a 2-tiered justice system: rules for thee but not for me. 2 sets of laws for 2 sets of people. A moral order shattered by leftist ideology. As Bastiat foreboded, quote, "When law and morality contradict each other, the citizen has the cruel alternative of either losing his moral sense or losing his respect for the law." End quote. Today, we are forced to choose between trusting a system that rewards criminals and punishes dissenters, or else rejection of the system altogether. Neither produces peace, which is, after all, the main purpose of the law in the first place. The law thus becomes a weapon. When we resist, we are told that we are opposed to solidarity. We are anti-progress. We are against decency. In truth, what we instinctively oppose is not the concept of charity or clemency, but being coerced into acceptance of what we know to be morally repugnant. Not freely given consent, but forced extraction. Bastiat called this false philanthropy. A legislator may sincerely believe that they are building a better world, but the result is still theft when the law is used to take from one to give to another. And this reveals the fatal flaw in modern Canadian governance: the arrogance of central planners. Bureaucrats believe that they can engineer fairness, equity, and moral uplift from above. They do not use citizens as agents of our own lives, but as material to be molded by ideology. Bastiat properly mocked this mindset. Quote, "The socialist thinks in all sincerity that there is the same difference between himself and mankind as between the gardener and his trees." End quote. In Canada, this is now the ethos driving disparate sentencing, identity preferences in tax credits, and ideological coercion within institutions like our law courts. It is not enough that we are equal before the law. The law must now ensure equal outcomes. Never mind that pursuing this course destroys actual justice. Bastiat warned that positive law, that which tries to do good rather than prevent evil, leads to endless conflict. Quote, "Depart from justice, and you will be lost in vagueness and uncertainty. The law becomes the battlefield for everybody's dreams and everybody's covetousness." End quote. On such a battlefield, law is no longer a neutral ground. It is a prize to be won. And every group, be it racial, sexual, or political, fights to seize it for their own exclusive benefit. And this is why Freedom Convoy organizers face stiffer sentences than violent criminals. They are not being punished for mischief. They are being persecuted by the state for challenging the system, for revealing its corruption, for having the temerity to exercise their constitutionally guaranteed right to express public dissent. Meanwhile, organized crime flourishes in Canada. Political elites share addresses with drug traffickers. Justin Trudeau reportedly took a private meeting with Paul King-Jin, a suspected kingpin of transnational Chinese organized crime. Conveniently, prosecutions of such persons collapse. RCMP financial crime units are inexplicably disbanded. Nothing is done. And why? Well, because in a regime of legal plunder, law enforcement is not concerned with justice. It is about optics, power, and protection. Those who warrant investigation host boxing events with politicians. Those who should be jailed or are waved through airports, flagged by border security. Meanwhile, those who dare to protest this corrupt regime risk frozen bank accounts, surveillance, and even prison. This is not just an erosion of our law, it is its inversion. When the law no longer punishes crime but rewards it, and sanctions the innocent for exposing it, then we are not living in a state of justice. We are living in a criminal empire where law becomes crime. As Edward Snowden puts it, quote, "When exposing a crime is treated as committing a crime, you are being ruled by criminals." End quote. Bastiat saw the destination clearly. Once plunder becomes legal, every group organizes to participate in it. The law becomes a tool of every ambition, every envy, every ideology. Eventually, it must collapse under the weight of its own contradictions. Canada is now a nation where legal plunder is not only public policy, it is the state's guiding principle. It is the foundation upon which our politics are now built. That is why every crisis becomes pretext for more redistribution, why peaceful protesters are far-right extremists, and every bureaucrat is our savior, why facts no longer matter, and why silence is now safer than dissenting speech. But silence will not save us. The only antidote to plunder is actual justice, not performative justice, not politicized justice, actual justice. The equal and impartial application of law to all of us, regardless of class, race, sex, creed, or political views. Frederic Bastiat was not just a critic of socialism. He was a prophet of tyranny. His message is clear. If we seek freedom, we must return to law as it was meant to be, a shield for all, not a sword for the few. But how can we possibly get there unless our courts adopt this principle? What hope do we have when our courts of law are agents of legal plunder? And to understand how politicized Canada's courts have become, we must first appreciate how judges once viewed their role, not as policymakers, but as interpreters of laws and the Constitution. In 1982, the late Supreme Court of Canada Chief Justice Bora Laskin said that justices have, quote, no freedom of speech to address political issues that have nothing to do with judicial duties. Absolute abstention from political activity is one of the guarantees of impartiality, integrity, and independence, end quote. Well, that was then, and this is now. In the post-charter era, too many judges have internalized the leftist living tree doctrine, the progressive idea that the Constitution continually adapts to evolving social and political contexts. Consequently, judges increasingly advance expansive positions based upon leftist political ideology. Governments elected to pass legislation are unable to tackle important issues without being overruled by the courts. They are spending millions in taxpayer dollars fighting charter challenges, often brought by only a handful of complainants. Just recently, Ontario's Supreme Court sided with just 2 University of Toronto students to stop the provincial government from dismantling bike lanes to ease chronic traffic congestion. Under the Charter's Section 7, protecting the right to life, liberty, and security of the person, the court ruled that the Ontario government cannot, quote, knowingly make the streets less safe, end quote. Talk about begging the question. Meanwhile, an effort by the Ontario government to remove drug injection sites, including near schools and daycare centers, has been paused by the court, pending another Section 7 charter challenge. In yet another case with major national precedent impact, Ontario's Superior Court held in 2023 that homeless encampments must effectively remain in place until shelter spaces are found for each resident. The City of Waterloo attempted via municipal bylaw to remove a 70-structure homeless encampment on city property. That bylaw was once again held in violation of Section 7 of the Charter. Quote, the constitutional right to shelter is invoked when the number of homeless exceeds available and truly accessible shelter spaces, end quote. That same court agreed in 2023 with just 7 environmental activists challenging Ontario's climate plan. It took judicial notice of the, quote, indisputable fact that Ontarians are experiencing an increased risk of death from climate change, end quote. According to eco-justice lawyer Fraser Thompson, who represented these activists, the ruling effectively boxes Ontario in and subjects its climate record to full charter scrutiny. The Supreme Court recently denied Ontario's appeal request in the case, which is now heading back to court. This, as similar youth-led climate cases are making their way through the courts in other provinces. Meanwhile, last month's International Court of Justice ruling that a clean environment is a basic human right was hailed by climate zealots as a major victory, which will inform future court decisions and legal challenges, including the new Federal Major Projects Bill C-5. Courts cannot be the exclusive arbiters of social and economic policy. Judges are unelected elites appointed through a highly political process by reigning federal and provincial governments. So what to do? Well, premiers are increasingly looking to the notwithstanding clause. Routinely called the nuclear option, it is actually a quite legitimate use of Section 33 of the Charter. It is also the most powerful tool governments have to assert parliamentary sovereignty over lawmaking. Let us not forget that from 1982 to 1985, Quebec notwithstood everything. More recently, Quebec and Alberta have considered forming an autonomy alliance, which could create a special deliberation mechanism for legislative bills and include the notwithstanding clause to dissuade court challenges. If only such a mechanism could reform federal catch-and-release bail laws. In 2023, Justice Harrison Arellano released violent offender Randall McKenzie, citing criminal code embedded bail rules mandating, quote, vulnerable population considerations. Quote, it's a very iffy case. I appreciate all the violence in his record, but part of that is his native background, education, and employment opportunities, end quote. 6 months later, McKenzie murdered OPP Constable Greg Pertzkala. The shocking case highlighted 2018 federal criminal code amendments ushered in by Jody Wilson-Raybould, which codified the principle of restraint, the idea that bail must be granted at the earliest possible opportunity on the least onerous conditions. Despite limited subsequent tweaks to the criminal code by the Liberal government, nothing fundamental has changed. When asked whether Canada is soft on crime, Canada's new Minister of Justice and Attorney General replied that, quote, we cannot operate in the space of slogans and sound bites, end quote. While having created an environment in which the property of Canadians is unprotected from theft, vandalism, and destruction, our courts now have gone one step further to vitiate our property rights altogether. In early August of this year, the British Columbia Supreme Court issued a decision that will ripple far beyond the Pacific coast. On the 7th of August, 2025, Justice Fitzpatrick released an 863-page judgment in Cowichan Tribes versus Canada. It recognizes something called Aboriginal title for the Cowichan Tribes on Lulu Island in Richmond. The court also confirmed a constitutionally protected food fishery on the southern arm of the Fraser River. This judgment did not come with the immediate seizure of homes or commercial buildings. Instead, it suspends enforcement for 18 months to allow governments to negotiate with Cowichan leadership. Yet within that same order, the court declared certain Crown and municipal interests defective and invalid. It directed both Canada and the province to reconcile Crown grants and third-party titles with the newly recognized Aboriginal title. This was not an isolated rural tract. The affected lands overlap industrial port terminals, container yards, municipal lands, golf course areas, farmland, and sections of Richmond's valuable waterfront. The decision punctures the assumption that urban developed land is exempt from historical title claims. How did this happen? Well, since 2019, BC has been legally committed to aligning all provincial laws with the United Nations Declaration on the Rights of Indigenous Peoples, or UNDRIP, through its Declaration on the Rights of Indigenous Peoples Act. This statute obliges the province to, quote, take all measures necessary, end quote, to align its laws with UNDRIP and to implement an action plan across all ministries. Key UNDRIP provisions relevant to this ruling include Article 26, which recognizes rights to lands traditionally owned, occupied, or used, and requires states to give legal recognition and protection to those rights. Article 27 requires a fair process recognizing Indigenous laws, traditions, customs, and land tenure systems. Article 28 prefers restitution of land over monetary compensation when land has been taken without consent. And these are not symbolic statements. They create a policy lens through which every government decision, legislative act, and court interpretation is now filtered in British Columbia. The 2023 decision in Gitala versus British Columbia held that the Declaration Act does not, without more, make UNDRIP directly enforceable in Canadian courts. However, it did clarify that provincial law must now be amended to comply. In other words, the Declaration Act is a policy spine. Once bent toward restitution, the system must follow. The clearest precedent for how this may unfold is the 2024 recognition of Haida Nation title over Haida Gwaii. That agreement between BC and the Haida Nation was ratified through legislation affirming Haida title across the archipelago. Private property continued under existing ownership, but the jurisdictional authority gradually shifts to the Haida Nation through structured reconciliation. Haida Gwaii demonstrated that it is possible to integrate Aboriginal title into the modern legal and economic system without triggering a market collapse. It also showed that once a recognition framework is negotiated, the precedent can be adapted to other rural or urban regions. This ruling is a seismic shift in Canadian law and life. Taking a 10,000-foot view, the pattern becomes visible. First, legal foundation. UNDRIP embeds the principle that Indigenous title exists wherever historical use can be proven. Second, legislative alignment. Declaration Act commits BC to aligning its laws and policies with UNDRIP. Third, judicial recognition. Courts, interpreting evidence through the UNDRIP lens, grant declarations of title even in densely populated urban areas. And finally, negotiated authority. Governments then negotiate implementation frameworks allowing private property to continue, but under a dual authority system. If you repeat this process across multiple regions, you normalize a structural shift in what ownership means. We move from crown-rooted title to layered sovereignty. We forge a reconciliation pathway to international governance. While reconciliation is often framed as a domestic process between governments and Indigenous nations, the Richmond ruling also reveals how this pathway can serve as a bridge to international oversight and influence under the United Nations system. The trajectory begins to look something like this. First, local recognition. Courts establish Aboriginal title and dual authority over land. Next, embedding UN frameworks. Domestic law incorporates UNDRIP, binding local decision to an international instrument authored and maintained by the UN. Third, expansion and replication. The model spreads to other jurisdictions, rural and urban, establishing a multi-regional network of UNDRIP-based governance. Fourth, international oversight. Disputes over rights and jurisdiction can be reviewed by UN human rights bodies or special rapporteurs on the rights of Indigenous peoples, giving international actors a role in interpreting our domestic land laws. And finally, sovereignty erosion, which is the real point. Over time, national governments retain nominal ownership frameworks, but the standards, enforcement mechanisms, and ultimate interpretations rest with a supreme international authority. Folks, this is hardly theoretical. In 2019, the UN Committee on the Elimination of Racial Discrimination, or CERD, formally warned Canada over the Trans Mountain Pipeline, Site C Dam, and Coastal GasLink projects. It urged suspension of these major national infrastructure projects pending free, prior, and informed consent from impacted Indigenous groups. In effect, an unelected UN body with no domestic legal authority applied pressure on huge projects impacting millions of Canadians. In New Zealand, the Wanganui River and Te Urewera forests were granted legal personhood under Maori governance, embedding a parallel authority system into their national law. In Australia, the landmark Mabo decision and the Native Title Act of 1993 have created a framework where Indigenous claims can reshape land use and governance at scale. The Richmond case follows the very same structural template, but in a major North American port city. This poses serious risks for property ownership, finance, and infrastructure projects in Canada. Firstly, consider mortgage security. A mortgage is only as strong as the certainty of its collateral. Counsel for the Cowichan Tribes indicates that some future transactions within the declared title area may require Cowichan consent or interaction with the Crown. That introduces new approval timelines and potential conditions precedent, altering lender risk profiles. Second, permitting and public works. The Richmond title lands overlap industrial corridors and municipal properties. Once the title is recognized, any Crown authorization, whether for infrastructure upgrades, diking, or port expansion, requires consent from the title holder or constitutional justification. Even with an 18-month suspension for orderly transition, the friction cost for projects will be magnified. Next, what about market perception? Well, Premier David Eby has said that private property with a clear title remains foundational. Those assurances are aimed at market stability, but are not legal guarantees. The Haida Gwaii model shows that private titles can remain intact whilst the underlying jurisdiction changes hands. And finally, Western allies and ripple effects. If you live in the US, you must understand that this is not merely a Canadian phenomenon. The precedent set in Richmond shows how UNDRIP and related reconciliation frameworks can be domestically seeded to alter property regimes, without legislative plebiscites on sovereignty transfer. The immediate impact that is most important to understand is that the Richmond decision brings Aboriginal title into an urbanized, port-adjacent environment. It suspends immediate enforcement but establishes the legal fact of title, directs reconciliation of Crown and third-party interests, and sets a procedural path for all future claims. Primary documents such as the full judgment and legal commentaries make it clear that this is both an historic recognition and a live test of how urban Aboriginal title will interact with modern markets. So what comes next? Appeals that may delay but not reverse the trajectory? Official mapping of the title lands for lenders and insurers? Negotiated frameworks modeled after Haida Gwaii? Replication of this reconciliation model in other jurisdictions such as the US, Australia, and New Zealand? This case serves as a reminder that property law can be altered without changing a constitution by embedding international frameworks into domestic law and then interpreting them through national courts. The Richmond ruling is therefore a clear warning that even land long assumed to be secure, urban, developed, and fully titled can be brought under new jurisdiction without public vote or legislative change. Property rights that once felt absolute can shift beneath our feet through a combination of court decisions, international agreements, and negotiated governance frameworks. The Richmond ruling is more than a local legal decision. It is a live demonstration of how the state can re-engineer society by fundamentally altering property rights, redistributing jurisdiction, and introducing international governance into local land management. It shows how very prescient Bastiat was 2 centuries ago when he described the right to hold personal property as vital to preservation of our civil liberties and to curtailing the growth of an all-encompassing, expanding authoritarian state. In an authoritarian state, rights derive from government and are granted to the people. In a free state, rights derive from God and are granted to the state. In the former, people are subjects, only allowed to own property, pursue an education, work, speak, and pray when and how their government permits. In the latter, people are citizens who agree to be governed in a covenant of consent that must be periodically renewed and is conditionally revocable. It is this clash between the authoritarian and the democratic that is the major ideological conflict of our time, not some concocted, prejudiced notion of an East-West divide or of a resurrected crusade against Christendom or Islam. Politics, religion, and culture are merely battlegrounds on which the main theater of war is waged. Authoritarian states are typically not governments of laws, but of leaders, who demand loyalty from their subjects and are hostile to dissent. Democratic states, by contrast, make no or few demands, but depend almost entirely upon each of us, voluntarily assuming the responsibility of protecting the freedoms of everyone else around us, regardless of race, ethnicity, creed, ability, sexuality, or gender. This is what it means to be equal before the law. And that equality consists not only of rights, but of freedoms, essential among which is to be protected from legal plunder by an oppressive state populated by greedy, evil men. We close with a quotation from former Prime Minister of Great Britain, the late Margaret Thatcher, who wrote, "A man's right to work as he will, to spend what he earns, to own property, to have the state as servant and not as master, they are the essence of a free economy, and on that freedom all our other freedoms depend."